Okay, so essentially today what we'll be looking at is arbitration practice and procedure. We'll also look at the knotty issues that typically arise in arbitration, and then the typical arbitration clauses or model clauses. What are the takeaways for SMEs? And then we do our conclusion. Now, in terms of the learning outcome, right? I hope that by the end of today, you'll be able to describe the importance, particularly for those that have not done arbitration before, you have no knowledge of arbitration. For some of us, we've done arbitration in masters and in PhD. So I assume that most of us today don't know arbitration, and this is the first time. And for some of us that have done arbitration before, this is just to further have that discussion. So I hope that you'll be able to describe the importance, the key principles, and the pillars of international arbitration. You'll also be able to explain the arbitration practice and procedure, useful for SMEs. You'll be able to understand the drafting and negotiation of arbitration agreements as it relates to SMEs and their businesses. We'll also be discussing the substantive legal issues arising in connection with formulation, validity, legality of arbitration agreements, the issues relating to presumptive separability of arbitration agreement. I'll be breaking this down into basic terms, as I progress in the discussion. We'll also be looking at the advantages and disadvantages of arbitration, the stages of arbitration, and then when you have the end goal or the end result of that process is an arbitral award, which is akin to the judgment that you have in court. So when you have that arbitral award in hand, what do you do with it? Then at that point, you'll be looking at the recognition and recourse against, in favor and against an arbitral award. Now, I've set out this because it's very important for us to understand, why this course in particular is, important for SMEs. Why is it important for SMEs? And the question that someone asked last year when we had this training for Nigeria, Ghana, Mozambique was that how does this course relate to us as SMEs? And the simple answer that I gave is that as an SME business owner in any sector, engaging properly with your legal issues and guarding against them is, going to potentially save you thousands of dollars. We all know that for some SMEs, just one big case can kill an SME, because if you have a case in court that is taking lots of thousands of dollars, from the income of the company, then the company can go bad. So it is very important that SMEs are able to manage their dispute efficiently. You understand, drafting and negotiation of contract agreement, because it starts before you even move to a contract. It starts with understanding how contracts are drafted, understanding negotiation of contracts, so that when your contract is one that is, foolproof. Well, we can't have a foolproof contract, but if it's a standard agreement, when dispute arises, you are well covered. So I've tried to show this data for you to know how important arbitration is. And when you look at this, you will see that it is important to pay attention to discuss the arbitration statistics published by the Business Dispute Register. Shows that the total global value of international arbitration is estimated at $86 billion US, and this was the figure in 2018. In that year, the London Maritime Arbitration Association administered most of the cases, even though the ICC handled the largest aggregate value of the disputes. And across the number of major institutions, about 13 of them, they managed over 6,000 cases, right? And this is just to give a background to the number of arbitrations that we have, every year. Some of them involve SMEs, so you need to pay attention to this course. So, question is, what is arbitration? And this is to then go deep into the meat of the discussion for today. What we know is that dispute is inevitable, even between husband and wife, siblings, brothers and sisters, friends. Disputes come up, they do happen. So same thing with us as SMEs running businesses. with contractors, with employees, disputes will typically happen. And then when they do, those involved have the option to try to resolve the dispute themselves or seek help from a third party or legal, or maybe initiate a legal action in court. In many situations, litigation can provide a definitive, that's going to court, a definitive decision about a dispute. For example, if you have a land matter and there is a question as to ownership or who is the beneficial owner of a land, or or title, maybe to get a definitive judgment or decision, you want to go to court. But in many cases, litigation has proved to be either costly, or the court proceedings or process have proved to be shown to be very lengthy. And that brings the importance, or shows the importance of AGR and importance of arbitration. And why is that so? Arbitration is a flexible and consensual means of resolving commercial disputes through a binding and enforceable process. The same binding and enforceable process you have in court is what you have in arbitration, similar to each other. The only thing is that arbitration is private, is not within the court system. And you also have impartial decision makers who are known as arbitrators that are selected by the disputing parties. So another thing is that as an SME that is involved in arbitration, you are able to select your arbitrator, who is going to be your arbitrator. And let me just compare this to what happens in the court system. When you have a case in court, for the AGR practitioners that are part of us today, they understand this. When you file your case, and the process is filed at the court registry, everything leaves your hand. Nothing until that case has been assigned. So the court takes your process at the registry, looks at the process that is good for filing. Then once you have filed, the matter is then assigned by the supervising judge to a court, one of the courts or one of the judges. Then they inform you that your matter has been assigned to a judge. You go to that court and then prosecute your case. And if you're a defendant, they serve you process, you go and defend it. But you have absolutely no power. You have absolutely no involvement in the process of selecting who your judge or who is going to be the decision maker over that dispute. Yours is just to go before that institution or make your case in a written form, and then allow that machinery of justice to run the way it has been designed. But arbitration is then different, because you get what is akin to what you have in court in terms of the decision, enforceable decision, but it can be in a way that you yourself have defined it or you have designed it. So you can design the process and the procedure. You can select who will be your decision maker, who will be your arbitrator. That is what makes it different from the court process. So what are the elements of arbitration? And this is similar to what you have in your, like I said, in your typical agreement. You have agreement to arbitrate. If you remember clause 20.2 in the contract that I showed you, it says that where the parties are unable to settle their dispute by way of negotiation, after 60 days, then they start that formal process of arbitration. So arbitration starts with an agreement between the parties to arbitrate. Because you're saying that the court should not administer your dispute, there must be an agreement between the parties. It means the parties must consent to use that process of arbitration before you can do arbitration. But an inquisitive observer can also ask that, but there are circumstances in which parties may not contemplate arbitration and can still do arbitration even where dispute has arisen. Yes, that is possible. And then that is what brings out the difference between what we call an arbitration clause. An arbitration clause is what is in clause 20.2 of that agreement, of the contract that I showed you. But we also have something that is called a submission agreement. And what is the difference between this submission agreement and the arbitration clause? Arbitration clause is when the parties are contracting at the stage of drafting their agreement, they contemplate using arbitration. We don't want to get stuck in the court. We want something that is, for example, court matters typically take between 3, 5, 8, 10 years, depending on the jurisdiction. I've done a case that lasted for 10 years, and I've done a case that lasted for 3 years. But typically, no matter how small the case is, you still run that machinery of justice through a number of years. In most countries, particularly in Nigeria, I think for Kenya too, at least you be in court for about 3 years. But I've done arbitration that lasts for 6 months or 4 months. So you can decide to say, okay, parties contemplate arbitration, we want to do arbitration, and you include arbitration clause in your agreement. So you have your arbitration clause that says where a dispute has arisen, it will be settled by way of arbitration. So that is an arbitration clause. But it is also possible that parties may not contemplate arbitration at all at the time of contracting.
Abayomi?
So, yes.
If I may, there's someone in the chat box saying that you should zoom out the elements of arbitration.
I should zoom out. Okay, yeah. Let me see if it's something that can be done. No, sorry. Oh, sorry. Is it better?
Yeah, way better.
Good. So now I was trying to explain the difference between an arbitration clause and a submission agreement, and we need to pay careful attention to this. So I was saying that an arbitration clause is when the parties contemplate using the arbitration for resolving their disputes. So at the time of contracting, parties have included arbitration in their agreement. So when you go to, I showed you the contract, when you scroll down from parties, the operative clauses, boilerplate clauses, and you get to dispute resolution, parties have included in that dispute resolution clause that, well, when the dispute arises between us, we will settle it by way of arbitration. But submission agreement is one that at the point of contracting, the parties did not contemplate arbitration at all. But when the dispute has arisen, parties then decide to settle their dispute by way of arbitration. And an example of this is, say, for example, the dispute relates to, say, an innovation or an invention. So two SMEs, say two fintech companies have come together to form like an innovative way of making payments. So it's an invention or an innovation. And you don't want that invention or innovation to become public yet. So about a dispute has arisen between the parties as to rights and obligations. So parties can decide to say, let's have a submission agreement where we agree to do arbitration instead of taking it to court, because we know when we go to court, things become public. But let's do this in a private way. Let's settle a dispute by way of arbitration. So an arbitration agreement that is made after a dispute has arisen is a submission agreement. An arbitration agreement that is made typically prior to the dispute arisen is what you call an arbitration clause that you typically find in your contract. So element of an arbitration is you have an agreement. It is very important. Same way you have your normal contract, there must be an arbitration, there must be an agreement to arbitrate. Then there must be existence of a dispute. Because if there is no dispute, there is nothing to resolve. There is nothing to use arbitration to resolve. So there must be a dispute, whether it's an existing dispute or a future dispute between the parties. Then the dispute must be arbitrable, and we'll get to this arbitrability in the course of the presentation. Arbitrable disputes are disputes that can be resolved by way of arbitration, because not all disputes can be settled by way of arbitration. And I alluded to one of it, an example the other time. I said if two parties agree to commit a crime, maybe to evade taxes or to do something illegal, and that agreement has an arbitration clause, can one of them enforce that agreement in court, or enforce that agreement to say, you must do arbitration with me? The other party can say, but this is an illegal contract, or this is a contract that is not arbitrable. This is a dispute that is not arbitrable. So a legal contract to commit crime, and a number of them that we'll consider in the course of the discussion that are not arbitrable. So it is important your dispute, that your dispute is an arbitrable dispute before you can use arbitration. Then element of it again is that it involves private persons who are decision makers. And I put the question here that does the arbitrator need to be a lawyer? And I sense that this is one of the questions that someone will ask. Yesterday, someone asked Mercy that do you need to be a lawyer to be a mediator? No. A number of mediators that we have today are not even lawyers. So anybody that understands that process or that has done a course around that area or build expertise around that area can actually practice mediation or act as a mediator. And you may not even have any formal training at all and still be a mediator. Once you're able to, you're a good listener and you're able to bring parties to amicable settlement, then you can be involved in that process. So same thing with an arbitrator. You don't need to be a lawyer to be an arbitrator. Your arbitrator can be, I've sat in as an arbitrator in a number of disputes that some of my co-arbitrators are not lawyers. There is one that I presided as the tribunal chair, and one of my co-arbitrators was an architect. So we see in recent time accountants, architects, medical doctors, engineers, that are appointed as arbitrators, and understandably so. You may want to appoint an engineer in a construction dispute because you know that maybe that engineer has the requisite technical experience or expertise, for that kind of dispute. So whilst you appoint lawyers, you also appoint an engineer to join that tribunal to be able to guide them when it comes to the technicality of the dispute. So you don't need to be a lawyer to be an arbitrator. Then another element of arbitration is that it is different laws are implicated, particularly when it is an international arbitration. You see the mix of different laws, sometimes mix of soft law instrument or application of soft law instrument, or the mixture of laws of different countries. So, for example, there's an SME in Kenya that has contracted with an SME in Tanzania, within the course of the contract, the law of Tanzania may become applicable and the law of Kenya may become applicable. So the interplay between these different laws sometimes are implicated in arbitration. You also have your final and binding award. I said the other time that in the outcome of the process, of the arbitral process, is a decision, and that decision is called an award. And that award is final, is binding, the same way you have your court judgment, and it also has an enforcement machinery that you can use to reap the fruit of your labor when you get an award. So these are the elements, some of the elements that I tried to quickly highlight. And then let me see if there's a question at this point. Any question before I then move to the next thing? So Samson says, what is the role of an advocate in arbitration? Well, I suspect that what you're trying to ask is, what is the role of a counsel or of a lawyer in arbitration? Well, a lawyer can function in two ways. I am a counsel, I'm a lawyer. So sometimes I get appointment as an arbitrator. I sit as the decision maker in the case. And sometimes I wear a different cap or a different hat by being engaged as a counsel, representing parties in the case. So instead of sitting down as a decision maker, I represent the parties as a lawyer to make their case before that decision maker. So the role of an advocate is, maybe either to sit as an arbitrator where appointed, or act as counsel, to properly guide the parties or to lead the parties that have engaged you through that process. Another question from Samuel: will the moderator share all presentation slides? Yes, we'll share all the slides with you. Patricia has asked that if a party feels aggrieved by the final award, can they appeal? Well, I will get to enforcement of an award, and then I'll also get to, and I said this in the when I set out the outline, I'll also explain recourse against an award. So if, for example, you are not satisfied with an award, there are limited circumstances. I've said that the arbitral award is final and binding on the parties, right? But there are limited circumstances that have been set out by the laws of different countries in Kenya, in Tanzania, and some other, international instruments like the New York Convention on the recognition and enforcement of arbitral award, which have been ratified by many countries, including most of the countries that are represented here. Sierra Leone ratified the New York Convention. I think last year it became operational last year. Then Kenya and Tanzania have also done so. So these international instruments have been incorporated into the laws of different countries. I know Sierra Leone is trying to amend the arbitration ordinance now to domesticate the New York Convention in Sierra Leone. So it has not become fully operational in Sierra Leone, but Kenya and Tanzania, the New York Convention applies. So that is the within the confines of the New York Convention or provisions of the New York Convention, and also the laws of different countries. The laws have set out limited circumstances that you can by which you can set aside an arbitral award or annul an arbitral award, but you cannot appeal against the award. There are some countries, though, like the United Kingdom, that allows limited grounds by which you can appeal against an arbitral award. But most countries don't allow you to appeal. What you typically do is to apply to set aside the award. And I will, in the course of the discussion, I will show you those circumstances and grounds. One last question before I move on. What happens when one party does not honor or enforce an award decision? What actions can be taken? Is similar to what Patricia has asked Rachel. So when I get to recourse or annulment of an award, you will see those grounds and how you can, which of them you can rely on. So moving quickly to the next slide. Okay. So this slide is to show us, I know I've referred to different advantages or benefits of arbitration, but this is just to then put them together in one slide so that we then see all those advantages. And then I've also tried to set out the downsides or possible demerit of arbitration. And if you look at your slide, you will see that one of the advantages of arbitration is party autonomy. I explained party autonomy the other time. I said the parties have the liberty to set out to determine the procedure that will apply to their dispute. The parties have the rights to also determine who will be the arbitrator or the decision maker. All these are things that you cannot do in court, because in court, the court already have their rules. You have to follow, you have to comply with the rules. The judge is appointed, or your case is assigned to a court. You don't have any control over that process, but you have a control over the process in arbitration, because you select your arbitrator, you select the procedure that will apply to your dispute. So all these are what we call party autonomy, because party have that autonomy, the independence to choose or determine the process as they want it, as it applies to their disputes. The second thing is cost. In court, when you go to court, typically, when you take your processes to court, what they tell you is they do a costing of your process and then tell you how much you have to pay. They assess your process. So you cannot argue with the registrar, the court registrar. What you do is just to pay whatever has been assessed for your dispute. So, and I've seen disputes that I've paid, that I've represented clients that have paid high costs because, so say for example, a client that is claiming $1 billion, what the person will pay as filing fees will be different from someone that is claiming, say, $1 million. So the higher the value of the claim that you have in court, the higher your fees. So, and then because of the length of proceedings of litigation can be costly. But in arbitration, you can, in a way, manage costs. So you can decide to select NCIA, that is the Nairobi Center for International Arbitration, where Victoria works, to say, okay, I know that to do my dispute, settle my dispute before the NCIA is going to be cost effective. Okay, parties can then agree to use NCIA. So you're able to manage costs. So another thing is confidentiality, particularly where it involves innovation, technical inventions that you don't want to be made public. You can keep the confidentiality of the process, of the dispute process, when you do arbitration. Also, arbitrators' commercial experience, and this is very important, and one of the key reasons why people select or go for arbitration is because sometimes, with due respect to the courts or to the judges, some of the judges were lawyers that were in practice. And some of them, when they were in practice, they had limited experience in terms of what they knew, what their practice was about, as it really covered. So by the time they then get appointed as a judge, you don't expect that judge to know beyond what he knew in practice. So most often what you see is that most judges don't have that commercial experience or the technical experience to deal with certain disputes. So a judge that has never done anything in maritime or construction, and you have a maritime dispute that's coming before that judge, most likely the judge will not be able to follow through the case when the case is being done. And then sometimes justice is not done to the process. So you may want to select arbitration, as a means of settling your dispute or resolving your dispute because of the commercial experience of the arbitrators. There's also procedural informality and flexibility. You can decide to have your arbitration in hotel. You can decide to have your arbitration anywhere, and you can use any venue to conduct your arbitration. But when it's a court process, you have to go to court and wait for the judge. Sometimes the court will not see it, and then you go back again over and over. But there's procedural informality and flexibility in the arbitration process. There's also time efficiency. When you compare the length of arbitration, I've done an arbitration that took like 4 months. And then I've done arbitration that took like 1 year or thereabout. But when you compare it to the litigation process, you see that it's more time efficient than the court process. Then there's neutrality, then likelihood of obtaining recognition and enforcement. Then if you look at the other side, look at my cursor, the downside, I said it may not be ideal for all types of disputes, which is true. I've explained to you that there are some disputes that are not arbitrable. Some disputes, even though they are not illegal, they are not criminal offenses or criminal acts, but they are just not, like, for example, so in some countries, contract relating to land, because it involves, a definitive decision in relation to the ownership to land, or because in some countries the statutes have already prescribed, the process for resolving disputes relating to land. So disputes relating to land may not be arbitrable, particularly where it involves a declaration over ownership of that land. Marital disputes relating to divorce or marital disputes in some countries are not arbitrable. Intellectual property disputes in some countries are not arbitrable. I know jurisprudence have emerged in some countries where they allow intellectual property disputes to be arbitrated. So it's not all disputes that are amenable to arbitration. Then sometimes you have conflicting awards. This don't happen often that you have conflicting awards, but sometimes it happens. And this is when you have two recalcitrant parties. One party has gone to, so assuming there's an SME A in Tanzania and SME B in Kenya, and they have an arbitration agreement. And instead of both parties coming together to follow through a process, one has started arbitration in Kenya, another one has started arbitration in Tanzania, and then they are running through that process. So there's a possibility of having conflicting award, in that regard, but it does not happen often. Then now arbitration is getting more expensive. The way arbitration was designed, when it first emerged, was to be like a competition to the court when it comes to costs, such that it is cost efficient and cheaper than court. But right now we see that we are beginning to have that narrative that arbitration is becoming more increasingly costly and expensive. But when you compare the length of proceedings in court and with arbitration, you see that arbitration is still cheaper than the court process. Then there's a limited coercive powers of arbitrators. Don't forget that because arbitration is a private arrangement of parties. So for example, you appoint me as an arbitrator. Me, I'm a normal person. I'm not a judge. I don't have an OD. I don't have police at my, beck and call. So because of that, because it's a private process, sometimes you need the courts, to give that coercive powers, or to use their coercive powers, in support of arbitration. So because of that limited coercive power, some people will say, instead of going to arbitration, I'd rather just go to court because I need an injunction and I want the court to be able to enforce that injunction immediately. But when you look at we do a cost-benefit analysis of both of them, you see that arbitration is still worth more than going to court. Then we're now getting into some of the technical parts, and I try to show you what an arbitration agreement should contain in terms of the formality, on how should it, what is the formality of an arbitration agreement. At common law, both written and oral arbitration agreement are valid. So you can decide to, as a matter of fact, in New Zealand, because that's a country that I know that today, they have clearly in their law, they allow oral arbitration agreements. Arbitration agreement can be oral. So you do not need to have it in any contract or have it written down. But in most jurisdictions, right, particularly with the provisions of the New York Convention, arbitration agreement will have to be in writing. And as you can see from the slide, Article 7.2 of the Austral Model Law. Austral Model Law is the United Nations Commission on International Trade law. They've set up, like, established a model law to guide parties when it comes to countries when it comes to arbitration. So if you look at that Article 7.2 of that model law, it says that a contract must be in writing. And I've tried to also set out Section 8 of the Tanzania Arbitration Act, that's the 2020 Act, says an arbitration agreement must be in writing. Section 4.2 of the Kenyan Act, and then when you look at the arbitration ordinance, importantly, the arbitration ordinance is dated. I am currently working with the government of Sierra Leone. I'm working with the Chief Justice and the Minister of Justice in Sierra Leone to help them, review the new arbitration bill to amend the arbitration ordinance. So today, what you have is a dated legislation that is formed, that copied verbatim an old English Act of 1880 something, right? So this arbitration ordinance is dated, but the government is making effort to amend it and then have like a modern arbitration law in Sierra Leone. But whilst there is no express provision that says your arbitration should be in writing, there's an inference that can be drawn from Section 2 of the arbitration ordinance. So in writing is, I've shown you section clause 20.2 of that agreement that I showed you initially. That's why that contract is important. When you take your mind back to clause 20.2 of that agreement, you will see that it says where parties are not able to settle their dispute by way of negotiation within 60 days, then they settle it by way of arbitration. So that is an arbitration agreement in writing. It means that parties have written it down. So in writing requirement is very important for you to have a valid arbitration. What standard arbitration clause? I've tried to show the ICC arbitration clause, so you see what an arbitration clause looks like. It says, all disputes arising out of or in connection with the present contract shall be finally settled under the rules of arbitration of the ICC by one or more arbitrators appointed according to the rules. So this can be dispute arising out of or in connection with the present contract shall be settled under the rules of the Nairobi Center for International Arbitration. So you can decide, and what are the takeaways from this? Let me just then explain. So this, I said, your arbitration will be settled under the rules of the International Chamber of Commerce, right? So what this contemplates is an institution is going to administer that dispute because we have said it will be under the rules of that institution. And then that brings us to the difference between ad hoc arbitration and institutional arbitration. Yesterday, I know Mercy tried to explain what an ad hoc means. What ad hoc means. So ad hoc means that two parties are controlling the process without the involvement of an institution. Whereas where you have said, okay, our dispute should be administered by an institute or an institution, then that means you are going for an institutional arbitration. In that case, you follow the rules of that institute. Here we have the difference between submission agreement and arbitration agreement. I'll explain it. Then I've also set out the requirement for an arbitration agreement. It says that it must arise out of the mutual consent of the parties. So there must be a consensus addendum between the parties. SME A and B that are going into a manufacturing or supply contract must agree that the dispute arising from that supply contract should be settled by way of arbitration. That is the mutuality of minds. So there must be a consent addendum or consensus addendum between the parties that arbitration is the dispute resolution mechanism that we are adopting for our contract. Then parties must have legal capacity. Agreement must be in writing. It must arise out of a defined legal relationship, and then the subject matter must be arbitrable. I've also set out the validity of arbitration agreements under the New York Convention. I'll skip through this. We can look at this later. And this is arbitrability. I've discussed arbitrability, but we can go through the slides again. I've said that it is not all disputes that are arbitrable. So SMEs should understand that when you want to choose arbitration or select arbitration as your dispute resolution mechanism, you have to look at that dispute to see whether it is one that can, even in the first place, be resolved by arbitration. And I've said disputes relating to patent and intellectual property in some countries are not arbitrable. Disputes relating to even elections in some countries, because there are statutes that have prescribed the process for resolving those disputes. So that is why you cannot contract out of those statutes. So for some countries, divorce proceedings, for some countries, land matters are not arbitrable. So you have to look at the applicable law to see whether your dispute is one that is arbitrable or not. So arbitrability relates to whether your dispute is arbitrable or whether it is not arbitrable, whether it is amenable to arbitration or whether it cannot be resolved by way of arbitration. And I've set out what the requirement of the model law on it says. Then competence, that's the competence of the arbitration tribunal. Now, the explanation to this is that, we've said that the arbitration is a private process. It is less formal. It's the procedural informality. Then the decision maker is a private person. He's not a judge. He's not the court, right? So the question is, there are some times that the jurisdiction of the decision maker, the powers of the decision maker are being challenged or are being questioned. So where, for example, one of the parties has questioned the competence or the power of the decision maker or the arbitrator, in that case, right, what will be the procedure? Will the arbitrator be able to determine it, or in that case, the parties have to go to court for the court to determine whether the arbitrator, has power to determine, as in to sit over that case? So the jurisprudence, or what has emerged in terms of in relation to arbitration, is that the arbitral tribunal has the competence, has the power to rule on its own jurisdiction. So it means that where one of the parties is challenging the power or the competence of an arbitral tribunal, of an arbitrator, you don't go to court to resolve it. What you do is you allow that tribunal or the arbitrator to make that determination by itself. To say, well, I've looked at this and I've seen that I don't have the power to do this, right? So that determination is made by the tribunal and not the court. So that is what is called competence. It means it came from a German word, competence. And what it means is that the arbitrator or the arbitral tribunal has the power, the competence to determine his own jurisdiction, to determine his own power in relation to a particular process. I've also tried to explain to you, so these are some of the key principles in arbitration that I'm taking us through, and I hope that you are able to capture some of these things. Now, the next thing is separability. And when you hear someone saying separability, or let me explain to you what separability means. What it means is that the arbitration agreement is separate from the contract. And if you recall the contract that I showed you, you see that a contract has so many clauses. It has parties, it has definition of terms, it has the operative part, it starts with recital, it has operative part, and it has boilerplate clauses where you have your waiver, separability, blah, 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 notices, then you have your dispute resolution clause. So when you look at it, the arbitration clause that is enveloped in a contract, the law is that arbitration clause is separate from the contract. And how does that work? How it works is that if, for example, you are challenging the validity of a contract, right, it does not affect the arbitration clause inside that contract. So you cannot say that, this contract is illegal, or this contract is a contract that I'm challenging, so that means I have to go to court to challenge it. No, you don't do that. The contract that is, the arbitration clause that is in the main contract, in the main agreement, is treated by the law as being separate from the main contract itself. So it's like taking out that arbitration clause in the contract, taking it out. So where the other part of the contract is bad, the arbitration agreement will still remain. So what that means in practice, the effect of that is that even though you are challenging a contract, the arbitration clause will still remain. What it means is that the dispute can still be settled by way of arbitration. So your dispute challenging a contract will not be taken to court. It will be done by way of arbitration. So that's what is called separability. Separability is that the arbitration clause is separate, or the arbitration agreement is separate from the main contract, such that where there is a challenge to the main contract, the arbitration contract will still survive. And what that means in effect is that the dispute that has arisen to the main contract will be settled by way of arbitration. So you cannot say, no, since the main contract is bad, the arbitration contract is bad, so I cannot go to arbitration, I have to go to court. No, you go to arbitration because the arbitration contract is separate from the main agreement. You have said you want to resolve your dispute by way of arbitration. So when that dispute has arisen, you resolve it by way of arbitration and not by courts. So it is a presumptive separation, and I try to break this English down. It is the way the law has presumed it, that, and the reason is that we don't want to have people that will have agreed to settle their dispute by way of arbitration, and when the dispute has arisen, they don't want to do arbitration again. They want to go to court. So they will just raise frivolous objections against the agreement and say, well, this agreement, I did not sign it, or this agreement, something happened, and because of that, they will say, well, the whole of the agreement is bad, I cannot do arbitration, I'm going to court. No. So the law presumes that the arbitration clause in the contract is separate from the agreement, such that even if you are challenging any part of the agreement, maybe payment or anything arising from the contract, the law will isolate that arbitration clause and say, okay, your dispute will be resolved by way of arbitration. The dispute or the challenge to the main contract will be resolved by the arbitrators. That is what separability means in the simple terms. And I've tried to bring out Article 16 of the Unsocial Model Law for you to see how that operates. Then quickly to take us through the stages of arbitration. This is very important. Maybe I should quickly look at the Yes.
There are still some people in the comment section saying that the view is too far away, that you should try to zoom in.
Okay.
So if you can.
Is it better now?
Okay. I believe so.
Yes. Let me see if there are questions. Okay. Dennis I said, in litigation, the parties are only concerned with the cost of their respective advocates. However, in ADR, the parties cater for both the mediator fees and their respective advocates. Well, good point. But you don't pay the judges, because the judges are employees of the states in a way. So they are paid by the states. Disputants don't pay judges. So what you do is just to file your process in court, pay the filing fees, and then pay your lawyers. But in arbitration, you do not only pay your lawyers, you also pay the arbitrators. Yes, you have to pay them because, we said it's a private way of resolving disputes. And then for their time commitment, you have to pay them for it. But then when you look at the cost overall, right, what you spend paying lawyers and then going through the litigation process for the number of years that it will run, and you compare it to what you pay arbitrators and lawyers when you are doing arbitration, you see that arbitration is still better off than doing court process. So if, for example, you're in court for 5 years, and then you continue to pay lawyers for 5 years, and then you do arbitration for 4 months, and you pay lawyers and the arbitrator, at the end of the day, what you pay may be less significant to what you spend when you're in court for 5 years paying lawyers. So that is why arbitration is different. And the reason for doing arbitration sometimes may not be cost, maybe, as I've said, to protect innovation or some other reasons, or maybe confidentiality or privacy of the proceedings, or just simply to have control over the process. And Tony has said in that Kenya and Tanzania SMEs dispute, okay, in that Kenya and Tanzania SMEs dispute scenario, which law will be applicable and where can the dispute be had? I suspect that what you are asking is, I've said SME A is in Kenya and SME B is in Tanzania. And then, there are two laws of Tanzania and the laws of in Kenya may be applicable. Yes, you have that interplay in international arbitration. But then I'll explain to you how it works. When you look at when the contract is drafted, right? In your contract, you have a clause called the governing law of the contract. What the governing law means is that when you you are selecting the law that where that contract is to be interpreted, that is the law that the court will use. That is the law that will govern your contract, your main contract. And that's typically the law that the court will use to interpret your contract. So parties select their governing law. So imagine in that scenario of the Kenyan and Tanzania SMEs, and then they've selected Kenyan law as the governing law. So keep that in one hand. Then they now come down to arbitration agreements. In the arbitration clause, they say, well, this when the dispute has arisen between us, we will settle the dispute by way of arbitration under the Tanzania, under the rules further to the Tanzanian Arbitration Act. So what they've done is to select the Tanzanian Arbitration Law or the Arbitration Act as being applicable to their disputes. So when it relates to the process or the procedure for arbitration, the Tanzanian Arbitration Act will apply. But when it relates to the interpretation of the contract itself, the Kenyan law will apply. So that is an example for that. Then, as I said, in litigation, the parties are only concerned. Okay, I think I've read this. What is the role of government in arbitration? Well, government don't have a role. Government can be parties to arbitration themselves. I've seen a number of cases where contractors to governments or counterparties in contract, have sued government, brought them before arbitration. But I suspect that what you're trying to ask is, how is arbitration regulated by the government? No, government does not have any regulation in arbitration except for establishing or enacting or amending laws relating to arbitration. So typically, laws will be made by government, the arbitration statutes or laws in the countries. But apart from that, they don't have any role in arbitration because it's a private dispute settlement mechanism. So it's between the parties. Government has no role whatsoever, apart from establishing the law in that country, or in some cases, and I think the Nairobi Center for International Arbitration was set up by an act. In some cases, they also set up arbitral institutions in different countries. I think even the Tanzanian Act also referred to the Tanzania International Arbitration Center, TAC, to administer disputes. Yes, so they can also set up administering institutions, that the parties can approach. But in terms of the process itself, government has no directing, working in that arrangement. I'll come back to more questions. So in terms of stages of arbitration, and this is very important, even for SMEs, we have to understand this because you don't want lawyers to come tomorrow and then begin to collect money from you, and you don't understand the process. So this is good so that when your lawyer comes to you, gives you advice, you can even discuss with them. Though I remember the professor that taught me arbitration in the SME ADR seminar. He taught us this. So the beginning of the process is the notice of commencement of arbitration. So if you recall the contract that I showed you at the beginning of the class, that contract has an arbitration clause, but it starts with negotiation. So it says when there is a dispute, parties will attempt to resolve their dispute amicably. And then it says where that dispute is not settled within 60 days, then parties will settle the dispute by way of arbitration. So assuming in this case, the Kenyan SME and the Tanzania SME, they've tried, the CEOs have met, maybe they met in Zanzibar in one beautiful hotel in Zanzibar, they have lunch, and then when they started discussion, tempers were high, they could not even finish the discussion, they could not even finish their meal, and each had to board flight and went back to their respective countries, and they could not settle the dispute. And after 60 days, the Kenyan SME has decided to start arbitration further to plus 20.2 in that contract that I showed you. So the beginning of that process is what is called a notice of commencement of arbitration. So what the Kenyan SME will do is to issue a notice to the other party, in this case, the Tanzania SME, to say, well, our contract says we should have settlement discussion, and after 60 days, we are not able to agree, we do arbitration. It's now past 60 days. We have not been able to settle this amicably. So we are intending to commence arbitration against you with regarding in relation to these disputes. And then they then send that notice of commencement of arbitration to the Tanzania SME. Typically, in your notice of commencement of arbitration, the party that is issuing that notice will have, nominated the person they want to act as arbitrator in that notice. So your notice will say, well, I'm commencing arbitration against you, and as the arbitrator that for the claimant, I am nominating Dr. Abayomi Okubote as our arbitrator. And they nominate me, and they send the notice to the Tanzania SME. And the Tanzania SME looks at it, the notice of commencement, and says, okay, well, we're happy to do arbitration. We'll come and face you before the tribunal. Then what they do is to send a response to the notice of commencement of arbitration to say, well, we're happy to go into the process with you. For the respondent, we are appointing Mercy Okiro, or we are appointing Victoria as our arbitrator in that case. So let me quickly explain, and that takes us to composition of the arbitral tribunal. So where the two parties have appointed two people to act as the arbitrators, then that means the tribunal is being constituted. But that is not the end of the process, because you cannot have an even number when it comes to composition of an arbitral tribunal. And why is that so? It is so because if there's an even number where the two arbitrators, for example, don't agree, it means there will not be anybody to break the tie. So typically in arbitration, we go for odd numbers. So it's either one arbitrator, a sole arbitrator, or it's a panel of three, so that the third person will be the chair. So let's go back to our scenario of Tanzania and Kenyan SME. So the Tanzania SME has appointed me as the arbitrator. The Kenyan SME has appointed me as the arbitrator. Tanzania SME has appointed Mercy Okiro as the arbitrator. Then the two of us come together and say, okay, we've been appointed as the third person to join us in this tribunal. We then appoint Joy Njagi as the third arbitrator. So Joy Njagi, that is the third arbitrator, then becomes the chair, the tribunal chair. So he's the third person that is being appointed by the two other arbitrators, the co-arbitrators, that becomes the chair. The chair being the person that will lead in terms of conduct of proceedings, the person that will manage that process and guide the other tribunal members. So that is how an arbitral tribunal is constituted. One party appoints an arbitrator, the counterparty appoints an arbitrator, the two arbitrators that have been appointed then appoint the third person, who then becomes the chair. And there may be a situation where the arbitration agreement has said it is one arbitrator. Maybe it's a simple matter. Typically, most disputes that relate to SMEs, the SMEs typically agree to have one arbitrator, because if you're having three arbitrators, it means you are paying three people. But if it's one arbitrator, it means you are paying fees to just one person. So typically, SMEs will agree. Most of the SME related disputes that I've handled, it's just a sole arbitrator that they will appoint. They will typically appoint. So then, if it's a sole arbitrator, party A will set out names. So typically, they can provide 3 names. Then party B will also provide 3 names. Then they have 6 names. They want to appoint one person, a sole arbitrator. So out of the 6 names, then they will now begin to prune down, then cross out some names. Okay, this one goes, does not have the relevant experience. This one goes. At the end of the day, they now prune down and say, okay, well, let's take this Mr. Abayomi Okubote. He has taught us before in an SME program. He has a PhD in arbitration. He has the requisite experience. Let's go with him. In that case, they then select a sole arbitrator that will administer that dispute, that will sit over that dispute. So in terms of composition of an arbitral tribunal, it's either a panel of 3 or a sole arbitrator. Then after the tribunal is constituted, typically the tribunal will constitute, or they will set up the first meeting, like the preliminary meeting between the parties. And that meeting is just to get to know the parties very well. So the parties will come before the tribunal. They've not started the formal process yet. So the parties will come before the tribunal. Tribunal will introduce themselves. Okay, we are the arbitrators in this case. We've looked at it. Then it is at that meeting that they then agree on a number of things that will guide that arbitration proceedings. They will agree on the procedure to be adopted. They will agree on the rules of procedure to be adopted. They will agree on the jurisdiction of the tribunal in terms of what the tribunal can do and not do. They will agree on how the proceedings will be conducted essentially. That's what is done in that preliminary meeting. And then after the preliminary meeting, the tribunal will issue what we call a procedural order number 1. That is of the first order for direction or order of the tribunal to the parties to say, these are the things that we agreed during the preliminary meeting that will guide this arbitration. That's the PO number 1. And after that, the parties, finalize the filing of the pleadings. If pleadings have not been exchanged, what we call pleadings are processes between the parties, the papers that the parties will file. So the claimant will file his own statement of claim to say, SMEA is owing me XYZ. I therefore claim $1 million. Then the respondent will be served with the processes with the statement of claim, and then will file his own response and say, well, I'm not owing because of force majeure. I could not deliver this because there was COVID. Because of COVID, there were restrictions by government, and there were I could not travel, flights could not move, so there was no way I could have delivered within that time. Just relying on force majeure, right? And then or frustration, depending on which one, whether it's contemplated by the contract or it is you are relying on the common law doctrine of frustration. So then says, oh, this is beyond me, that's why I could not, then file his own response. So pleadings will then be considered by the claim process showing the claim by the claimant, and then the rest processes showing the responses by the respondent. Then you have your pleadings. Your preliminary meetings, I've said it, I've referred to it. Then discovery. Discovery is where you need to recover documents from the other party, documents that are relevant to the proceedings. Then you can bring application for the other party to furnish the tribunal to order the other party to furnish those. And sometimes you just give a notice to produce to the other party, and then they produce the documents. Then we then move to hearing and taking of evidence. This is the important part for us as tribunal members. Sometimes it can be lengthy proceedings. Sometimes, particularly during COVID, that we had to be doing our application proceedings online. Just sit down in front of system for a number of hours, people making cases, but then they are connected from different countries. So hearing and taking of evidence where it is in person, physical, typically we'll have like maybe it's one hotel or hearing arbitral institution that you are using. You have like a conference room or hearing room. You sit down, the claimant on this side, the respondent on the other side, the tribunal members will sit close to them, and then they will then call witnesses if it is one that involves hearing of oral evidence. And as in some cases, parties will agree that there's no need for oral evidence, and then what they will just do is written. It's going to be like a written arbitration where you just make written submissions. Then, like I said, the outcome of the process is the arbitral award. So once you have the process, or you've filed all your processes, you've taken evidence, everything has been submitted to the tribunal. Then the tribunal, you have concluded proceedings. The tribunal will then retire to their chambers, the tribunal members, and then consider the dispute, the processes that have been filed by the parties, the evidence that have been made by the parties, and then make determination in that way, whether in favor of the claimant or in favor of the respondent. So that decision by the tribunal is called an award, an arbitral award. So the arbitral award is not self-executory. Don't forget that it is a decision of a private individual. It can be me. I've written several arbitral awards, and that award, you can't just say you want to go and call police to come and enforce it for you. you still need the machinery of the state or government to enforce it. So what happens is that you take your award to the courts to register it. So in some countries, all you need to do is just to file an application for registration. In some countries, you file an application for recognition. So you bring that award essentially before the court, for the court to recognize it as its own judgment, so that you can then rely on the enforcement machinery of the state, for the purpose of that enforcement. But at the time that you are enforcing that award, the counterparty or the respondent or the award debtor can then come before that court to say, well, this award that this person is holding is not good, it's not one that the court should enforce for X, Y, Z reason. And I will show some of those grounds very soon, and then say this is an award that the court should not enforce. So that is the procedure. Moving swiftly. I know I've gone past my time. I will skip this virtual hearing. Virtual hearing is, during the time of COVID, we had to move hearing online. So unlike the way you go to court and have your court proceedings, wig and gown, for us in arbitration, we also have in-person hearing. You have lawyers that come before us as arbitrators, make their case before us, and then we make our decision. But when COVID happened, and prior to COVID, that we had circumstances or situations where we had to hold proceedings or hearings online. But when COVID came up, then it now became more like a new normal, like a normal thing for us. So because of that, most proceedings moved online, and then a lot of things then started happening online. So that's why I showed this, but I'll move quickly past it. So now to arbitral award, we are getting close to the end of it. What are the requirements of a valid arbitral award? Because it's not enough for you to have an award in hand. Before that award can be enforceable in court, before the court can enforce it, the award must comply with some requirements. The first thing is that the award must be in writing. So the arbitrators or the decision makers cannot simply say you have won, or we have determined the case in favor of the claimant, and then go away without anything in writing. So the award has to be in writing, like your normal judgment, and then it must be final and binding on the parties. There's also a requirement that the arbitral tribunal must state the reasons for the award. What this means is that it is not enough to just write an award and say the case is won by X or the case is won by Y. You must provide a reasoning for that decision that you have given. So X has won because you have looked at the totality of the evidence before the tribunal, which points to the fact that there was an agreement between the parties to supply, and then even though this person, COVID had happened, but there are other means by which the contract could have been performed, and that COVID is not a valid decision, it's not a valid defense in this case, because there are other means by which you could have gotten it across, just providing a reasoning behind the decision, or a reasoning for the decision you are making. So it's not enough to just state the decision without providing, the basis for it. That is a requirement. Then there's a requirement that shall be signed by, the award shall be signed by the arbitrators and shall contain the dates. And sometimes you have to be careful with the different jurisdictions. The last arbitral award I wrote was a dispute in a North African country, one of the North African countries. And then there's a requirement of, in that country, by the law of that country, that an arbitral award must be signed, or must be signed by the arbitrators, and then initialed, by the arbitrators must initial all pages with wet ink. You know what that means? What that means is that you must use your ink to initial each page. So in that case, we had 3 arbitrators. I, being a Nigerian, another arbitrator from Tanzania, another arbitrator from Egypt, and then there's a requirement that all of us must sign with wet ink, meaning that we cannot use online or signature or kind of initial online. So they have to first send to me. I signed, I initialed with wet ink, I sent to this person in Tanzania, the person signed and initialed with wet ink, then sent to But because that's the requirement of the law, the governing law of that arbitration, you have to follow that requirement. Otherwise, that award will not be valid. So you have to be careful to see what are the requirements of the law of the governing law of the arbitration. And the last thing is that the award may be made public only with the consent of the parties. Copies of the award signed by the arbitration shall be communicated. So typically in arbitration, you only send the decision to the parties. It is not made public. You can't make it public. You can't go and publish it online. Or someone cannot apply to you or send message to you that they need a copy of it and give it to them. Don't forget that arbitration is private and confidential. So it's only the parties that have access to the award. The only way that the award becomes public is when they have gone to court to enforce that award, and then they filed an application in court for the purpose of enforcement. Then anybody can go to court and apply for a CTC, a certified true copy. But as between the arbitrators and the parties, the award must be confidential, except where the parties have expressly consented. And we typically see this in investment arbitration cases, where parties agree that the award can be published. Other than that, arbitral awards are typically confidential and limited to the parties. Circulation is limited to the parties. So someone asked a question that how do you go after an award? If an award, you are not satisfied with an award, what are the things that you need to do? But before that, I thought to show the process or procedure for enforcing an award. So we've said that an award shall be recognized as binding upon application to court. So you file an application to court for enforcement. So the laws of the countries are similar. Same, what you find in Section 36 of the Kenyan Arbitration Act is what you find in Section 78 of the Tanzania Arbitration Act and Section 13 of the Arbitration Ordinance in Sierra Leone. And it's also similar to what you find in Section 53 of the Nigerian Arbitration and Conciliation Act and most of the other laws. And what the law typically requires is that when you are filing an application for enforcement or recognition of an arbitral award, you need to supply a duly authenticated copy of the award, original or certified copy of the award. You know that award is not made by the court, it's made by the tribunal. So you need to bring to the tribunal the original or a certified copy of it. Then you also need to bring the arbitration agreement. That means you have to bring the contract that shows, because the reason is that the court will have to be satisfied that the parties actually agreed to settle their dispute by way of arbitration. And then they look at the outcome of that process, which is the award, before they will then recognize or enforce it. So you need to supply a duly authenticated original award or a certified copy. You need to supply the arbitration agreement or a certified copy of it. And then if any of this is not in the language of the court, typically English language, then you have to do a translation of that document into English, and then or that should be duly authenticated. That is the requirement of the laws of most countries in relation to how you come before a court for the purpose of filing an application for recognition. Then recourse against an award. This is a question that has been asked, that when you are not satisfied with an award, can you set it aside? What can you do? Can you appeal? And I've said that in most countries, appeal is not allowed, except for countries like UK, where in limited circumstances you can appeal against an award. Appeal is not allowed. What you can do is to file an application for annulment of the award or setting aside of the award. What you find in Section 35 sub 3 of the Kenya Arbitration Act, which is similar to what you find in Section 51 of the Arbitration and Conciliation Act in Nigeria, and what you find in Article 5 of the New York Convention. They set out limited circumstances that you can apply to set aside an award. One of it is one, where the arbitration agreement, where the parties were under some sort of incapacity, or the arbitration agreement is defective. So if it is a defective arbitration agreement, then the court will not enforce that award. Or where the parties were under some incapacity, in terms of making, when I refer to what Ubin did yesterday in terms of validity of a contract, I said there must be an agreement, constitution, capacity, and intention. So where there is no capacity between the parties that are making the arbitration agreement, then the court will not enforce that award. Or where the arbitration agreement itself is invalid. Then where the making of the award was induced by fraud or bribery or undue influence or corruption, then the court will not enforce such arbitral award. So rounding up this session, so that I can allow my very good friend Victoria to take us through the arbitral institutions, what they do in relation to arbitration, and what they have for SMEs in relation to ADR. I thought to summarize the takeaways, the key takeaways from this session. And one of it is that due to the formality and the prohibitive cost of arbitration, because of litigation is expensive due to the number of years you spend in court. SMEs should take advantage of the arbitral process by including arbitration clauses in their contract. So when you are drafting your agreement, try to include arbitration clauses. At least include ADR provisions, either negotiation, mediation, or arbitration. And being an arbitrator, I always advise you to include arbitration clause in your agreement, so that when the dispute has arisen, you can then take advantage of the attractiveness of arbitration as a dispute resolution mechanism. Then the second thing is SMEs should pay attention to the arbitration clause in the contract and the person that they appoint as the arbitrator or counsel. Or someone approached us in my law firm yesterday that just to ask us to on a potential engagement, and then told us that he had appointed an arbitrator who he found out that arbitrator that he appointed was colluding, with the counterparty, the opposition party, and he was one that appointed the arbitrator. There are so many things that happen. It doesn't. Well, let me say that that does not happen often in arbitration, because most of us that act as arbitrators are extremely gentlemen and well-behaved people or persons, but then there are still some few bad eggs. So you have to know the person that you are appointing, and it's not also the case of corruption or alone. It's also the case of that it's also the case that the person must have the requisite expertise or experience in relation to that dispute and is able to administer that dispute very well and write an enforceable award. Then pay attention to the arbitration clause. If you cannot draft an arbitration clause, don't just go and do copy and paste. So that one professor has shown us an arbitration clause, let me just copy and paste it, or you go to the internet and copy and paste it, or from a formal contract. No, pay attention to the arbitration clause. The reason is that when dispute arises, it is what will save you, what will save your money, or possibly by extension your investment, is a properly drafted dispute resolution clause. And when you are doing arbitration, a properly drafted arbitration clause. So please pay attention to the drafting. Make sure that it is one that is properly drafted. And then arbitration may be considered as a mix with other ADR processes like mediation and negotiation. If we look at the contract that I showed you, that clause 20, you know that it started with negotiation. And it says where parties are not able to negotiate or settle their dispute amicably after 60 days, then the dispute will be resolved by way of arbitration. So you may not need to go to arbitration directly because it's a formal process. You may decide to first do negotiation or mediation before you do arbitration. In that case, it's more advisable, because it may be the case that the dispute is one that does not need to go to arbitration, or we can settle it by way of mediation or by negotiation, and then you need to do a formal process. Another thing is that SMEs must devise means of managing their disputes efficiently to ensure business sustainability and profitability, which is the reason why we have set up this training with the great support of GIZ to, help SMEs manage their dispute efficiently, and which starts from how you draft your contract, how you draft your arbitration agreement, how you draft your dispute resolution clauses, how you negotiate those clauses and contracts. Make sure that they are well drafted, and where a dispute has arisen, how you are able to take advantage of ADR as a dispute resolution mechanism for resolving your dispute. On this point, or at this stage, I've come to the end, but I will go back to the Q&A box and answer as, tell me how many minutes do I have, or have I around my time?
Yes, you have gone beyond your
Okay.
time, but you can take about 5 minutes to answer some of the questions.
Okay. Thank you very much. Someone has asked that is employment contracts a settlement part? Okay.